this honorable court.
Thank you. You may be seated. All right, we have two related cases on our docket this morning. We'll take them in the order that they're noticed, the 94 case and then the 96 case. And we can do them one after the other, and we can take a little time to break between the cases. There's no need to switch sides or anything, but we can just keep going. So if counsel for the first case is case number 22-2094, Verizon Communication Affiliates versus State of Florida Department of Revenue. If counsel for Verizon is ready.
Your Honor, one note. I think your names are missing.
Does it matter?
That is true. Well, I'm Thomas and she's Kelsey, or you could just say, hey you, how about that?
Thank you.
Thank you.
May it please the court, Michael Bowen for the appellant, Verizon Communications, Inc. and Affiliates. I'd like to reserve 3 minutes for rebuttal.
Noted.
The order of the lower court granting summary judgment to the department must be reversed for the following 3 reasons. First, the legislature has made clear that Florida's tax laws conform to the Federal Internal Revenue Code, unless the legislature has stated its intent to the contrary. The legislature has not disassociated Florida law from the federal mitigation rules in the Internal Revenue Code. Therefore, consistent with its legislative intent, the federal mitigation rules are part of Florida law. Second, in Seaboard Coastline, this court explained that the legislature's intent was to harmonize Florida's corporate income tax regime with the federal blueprint. In that case, this court determined, without controversy, that a concept of federal law substantially similar to the mitigation rules was incorporated as part of Florida law. Finally, the fact that Florida's statute of limitations may be a statute of non-claim is irrelevant to this appeal. The statutory language of the federal statute of limitations has also been determined to be a statute of non-claim. Yet the IRS and federal courts routinely treat the federal mitigation rules as an exception to the federal statute of limitations.
Counsel, let me start there while you're there. There are a couple of statutory things that for me seem to be very important on this issue. And the first on the non-claim, I think that's 215.26.
Yes, Your
Is
Honor.
that right? And subsection 4 says this section is the exclusive procedure and remedy for refund claims between funds and accounts in the state treasury. First, it says this section is the exclusive. So is there anything about mitigation in this section, and how do we deal with the fact that this section, that this law says it's the exclusive place that we should look?
First of all, subsection 4 refers to the exclusive remedy, meaning if you're going to pursue a refund, you have to do it pursuant to 215.26. It doesn't talk anything about exceptions to statute of limitations. It says that's the sole remedy. Secondarily, the United States Code, section 6511, has a federal statute of limitations, which is substantively identical to Florida. It's not exact, but identical in its language. And that statute has been recognized to have an exception to it as the mitigation rules. I hope I've answered your question.
Okay, but you are seeking a remedy.
We're seeking a refund.
Talk to me about the remedy that you're seeking and how that doesn't relate to this section.
Well, we are seeking a refund, and we have pursued a refund claim consistent with Florida law. The department has not said that our claim is deficient, meaning we have followed all the rules to pursue the refund claim. The amount of the refund claim hasn't been challenged. The timeliness of the claim having been raised has not been challenged. And ultimately, the federal requirements under mitigation have not been challenged in this case. There's been no dispute as to any of those facts. The only issue for this court is whether Florida law adopts the federal exceptions to the federal statute of limitations under Florida law.
Can I maybe rephrase that a little bit? More conceptually, it sounds like you're kind of relying on federal concepts as controlling Florida law, but it seems to me that this court can't pick a concept out of thin air and inject it into rules and statutes where the legislature and the department haven't done that. That's more, more conceptual way to look at this argument. Can you address why we should read that in there when the legislature and the department have not done that?
Yes, Judge Kelsey, and I will disagree somewhat, in the sense that Section 220.02 of the Florida statutes states, quote, "It is the intent of the legislature that the income tax imposed by this code utilize to the greatest extent possible concepts of law which have been developed in connection with the income tax laws of the United States." This was put in place the exact same year that Florida adopted and enacted the corporate income tax provisions that we are dealing with here today. So the legislature of Florida articulated its intent to borrow from federal law, which makes sense if you think about it. The United States corporate income tax has been around forever. There's no need for Florida to reinvent the wheel. So the only thing that Florida really need do is come up with whatever exceptions it wants to deviate from the Internal Revenue Code. That same Florida statute, 220.02, articulates all the reasons why it makes sense to borrow from the federal provisions, most notably efficiencies to both taxpayers and the department of not having to recreate the wheel every time they want to try and solve a tax problem.
That was the other part that was important to me here. The rest of you read the rest of subsection 3 that you just read talks about the intent of the income tax imposed by this code utilize the greatest extent concepts of law in order to. There's a purpose statement there, and it seems like, just as you said, that the purposes there are efficiencies. To minimize expenses of DOR, to minimize costs and difficulties for taxpayer compliance. And so this utilization seems to be for the purpose of efficiency, and I understand your argument as to mitigation to be something that's more in the nature of a fairness and equity concern and not particularly efficient, because it seems like you'd have to keep records for an additional long periods of time, and we're arguing about things that are 23 years old and things like that. Why does this section as drafted even apply when we're not really talking about, we're talking about an inefficiency, but maybe a more fair outcome?
I think that there's been a I was going to get to this a little bit later in the argument, but I think it's important to address it now. The department's concerned that there's some sort of inefficiency here. There's a records issue. The mitigation rules, again, apply in very, very, very narrow circumstances. Even in federal law, it rarely applies. Only under certain very discrete, specific circumstances that the department has not questioned have been met here. So the statute of limitations can only be reopened under very limited circumstances. It is true that the tax years that we're talking about here, again, which the department has not disputed, go back a ways. But again, Verizon is not a small taxpayer. The audits of taxpayers like Verizon do take time, and the actual audit years that are before this quarter, 2011 through 13. So even they are old. The reality of what happened here is that Verizon was not made aware of its ability to qualify for mitigation until certain events took place, events that federal law anticipates would happen and did happen here. So, the one other issue, Your Honor, that you mentioned is record keeping. The department's concern about record keeping has nothing to do with them. In the event that this court were to determine that Verizon qualifies for the mitigation, it's Verizon's burden to have the records. Verizon just can't say, we qualify, therefore entitled to the refund. They still have to be able to substantiate that they're entitled to it and with their own documentation. It's their obligation to retain the records, not the department's. So in the event that there's some sort of inefficiency, it works to the detriment of the taxpayer in this case, because it is the one that had to have the records substantiate the refund. Now, Judge Osterhaus, in this case, that doesn't matter. And what I say by that is the department's conceded all that. They haven't disputed the documentation exists. They haven't disputed the amount of the refund. They haven't disputed the tax year to which the refund relates. They haven't disputed that the mitigation rules have been satisfied here. So all of this smoke and mirrors about record keeping and slippery slope of the long period are really just a function of the fact that Verizon is a very big taxpayer. The audit took a very long time to be audited. And Verizon has a situation where they've already had the documentation. Now, in many mitigation cases, you might not have to go back that far. documentation would be easy to have. But again, this is the taxpayer's burden.
Well, and I think my question goes to more of a 35,000-foot level question of, you're asking us to read into the non-claim statute an intent provision of Florida law, and the intent provision is bent on efficiency, and your argument really isn't about efficiency, it's about fairness and equity. That's what mitigation goes to. It doesn't go to efficiency because it's not particularly efficient to have an overlay of mitigation rules on a very clear rule. Why do we read in something that's bent on efficiency as changing something from efficient to an inefficient rule?
Well, I think that the federal statute of limitations, again, is also a statute of non-claim. And certainly efficiency is important to federal law as well, but it's a well-recognized exception to the federal statute of limitations that they have the federal mitigation rules apply. In this case, it appears inefficient, again, because of the age of the years that we're talking about at the end of the day. But that doesn't always have to be the case. But one more point, Your Honor, I want to get out, is that the mitigation rules work both ways. It's not just, it happens to be in this case that Verizon can benefit from the use of the mitigation rules. The department under the federal mitigation rules can also benefit. For example, in the event that the department were to have allowed Verizon to take a deduction in an old closed tax year, erroneously allowed Verizon to take that deduction, and in the current year, it allows them to take it again on the same return, legally take it again, the department could use the mitigation rules and open up that closed tax year for Verizon and assess Verizon for taking the deduction the wrong year.
Yeah, and I get all that, and I get why that might be the best rule, but what I don't get is a statute of non-claim is very efficient, right? It's clear, and either you are or you aren't, you're in, you're out. To overlay mitigation rules introduces a lot of, okay, what's happening here, and should this come in, and it's not efficient. It might be a better rule, fairer rule, policy-wise, but for a provision of law that's seems bent on efficiency, to overread that into something that is very efficient is where
I understand.
I'm having trouble.
And the department's concerns about ultimately finality, making sure that years are closed, efficiencies in that regard, let's not pretend that that's only a concern for the Florida Department of Revenue. The Internal Revenue Service processes how many millions of returns every year? Certainly, finality and efficiency, and even under federal law, the statute of non-claim and a doctrine of laches, all that still applies. Yet for federal law, it's recognized, dating back to 1938 when the mitigation rules were put in place, that this is a very limited exception, and in these circumstances, Congress determined that fairness trumped that efficiency. And we believe that that concept of law ultimately is part of Florida law because the legislature intended to adopt and take into consideration all federal provisions that are not otherwise excluded. And in this case, the Department of Revenue, through the legislature, decided not to exclude the mitigation rules. Regarding the position that the Department of Revenue has raised that under Victor Chemical, which is, I think, their sole case that they rely on here, their lead argument is that Section 215.26, outlining the statute of limitations for claiming refunds under Florida law, is a statute of non-claim that permits no equitable exceptions. Again, this is a meritless argument for the reasons previously mentioned. The federal statute of limitations, 26 U.S.C. 6511, has also been determined by the U.S. Supreme Court to be a statute of non-claim. Yet, it's commonly understood by the Internal Revenue Service, who doesn't fight it, and the courts who enforce it under federal law, that the mitigation rules apply. Therefore, Victor Chemical, although an interesting case, is really not relevant to this case because the mitigation rules are an exception to the statute of non-claim. Your Honor, I've exceeded my rebuttal time. I'd like to reserve the balance.
Thank you. Mr. Cox.
Thank you, Your Honor. May it please the court, I'm Clifton Cox, Special Counsel for the Attorney General, and I represent the appellee in this case, the Department of Revenue. This case hinges on the extent to which the Florida corporate income tax piggybacks the federal income tax. Florida begins with federal taxable income on line 30 of the federal income tax return. Florida then makes various adjustments in section 220.13 to compute adjusted federal income and further adjustments to compute taxable net income. Florida also follows federal terms and concepts, but that's the extent to which Florida law piggybacks the federal corporate income tax.
Can I ask a quick question? This is just for information. The adjusted federal income on a federal tax filing will be a different number. In this case, maybe for Verizon would be a bigger number than a Florida adjusted federal income. Am I right? That
Not
there's a
necessarily,
Florida
Your Honor.
income and then there's a national income.
Not necessarily.
I get that, yeah.
Florida begins with line 30, which is federal taxable income on the federal tax return. But Florida then adds the various items listed in section 220.13, subsection 1A, and subtracts the items listed in section 220.13, subsection 1B.
Is that stuff like income from all the other states or whatnot that's not Florida?
That comes later, Your Honor.
Oh, okay.
That's after you have the adjusted federal income, then the department makes various additional adjustments dealing with non-business income allocated to Florida or other states, the apportionment of income, the unitary business income worldwide to compute the taxable net income in Florida. So the extent of Florida's adoption or piggybacking of the federal tax is limited to the starting point of line 30 and the fact that for efficiency's sake, Florida adopts the terms and concepts of federal law. Now, Verizon misreads the Seaboard Coastline case. The key language in that case.
So very quickly, I'm sorry, but going back to my question, so
Yes, sir.
before you strip out all the state-oriented stuff, you're dealing with a federal number, and so the federal and the state form is going to look the same by the time we get to the issues we're dealing with here, essentially. I mean.
No, Your Honor. There are, because of those changes in section 220.13 that add some things and subtract some things, that's why you can have very different numbers for Florida NOLs or federal NOLs, why you can have, and of course NOL refers to net operating loss. And so there can be a profitable federal tax and a net operating loss for Florida or vice versa. Now, Florida's tax return is known as the F-1120 or Florida 1120, and the federal income tax return is the federal 1120. So the Florida income tax return deals only with adjustments after that federal taxable income on line 30. Did I answer your question, Your Honor?
I think so.
Okay,
Thank
thank
you.
you. Now, Your Honor, we believe that Verizon misreads the Seaboard Coastline case. The key language is at page 480, Southern 2nd, 1353. On that page, the court explains Seaboard filed amended federal income tax returns. Those amended federal income tax returns were audited and approved by the IRS. Seaboard then filed amended Florida tax returns, making the same adjustments that the IRS had approved on the federal tax returns. The present case does not involve any amended federal return if the refund claim were based on an amended federal return, or if it were based on an IRS audit. Pursuant to section 220.23, Verizon would have had 60 days in which to file a further amended Florida return and an additional 2 years to file a refund claim in Florida. But because this case does not involve an amended federal return, The Seaboard Coastline case is totally irrelevant. It actually would support the department's position because the department notes if this refund claim arose from a federal amendment, Verizon would be entitled to it in Florida. It didn't, so they aren't. Now, the federal mitigation statutes mitigate or modify the federal statute of limitations in Section 26 U.S.C. Section 6511. Now, the case law that I've read indicates that the courts recognize that the federal statute is a statute of limitations, which is an affirmative defense. It does not deprive the courts of jurisdiction to hear the refund claim. One of the cases that the appellant cited, the Plausch-Lam case, noted that it is a federal statute of limitations. Now, Florida has its own statute of limitations on tax assessments, Section 95.091. And Florida has its own statute of non-claim for refund claims, Section 25.26. So there is no need for Florida to adopt the federal statute of limitations or any statutes that modify the federal statute of limitations. We would submit that Victor Chemical is dispositive. The Florida Supreme Court followed Victor Chemical in 1999 with the Department of Revenue versus Nemeth case, and if I remember correctly, the citation was 733 Southern 2nd 970. In that case, again, the Florida Supreme Court recognized that Section 215.26 is an absolute standard of efficiency. If a refund claim was filed, even in the Nemeth case, based upon a tax being unconstitutional, if that refund application were filed outside of the statute of non-claim period, it's barred. The court has no jurisdiction to consider it.
Are there instances where there are exceptions to the statute, the Florida statute of non-claim, that aren't dealt with in 215.26?
Your Honor, based on my research, no. Now, there are a couple limited situations where there is a tolling provision while an audit is underway. If the audit lasts for no more than 1 year, the certain deadlines are tolled. But for purposes of refund claims, other than those arising from amended federal tax returns that are addressed in Section 220.23, Section 215.26 provides efficiency and certainty. Now, Florida, unlike the United States, we have to have a balanced budget each year. We can't go back in time to grant massive refunds that would put previous years, would potentially create problems because of that.
So if Florida had mitigation rules similar to the federal government, you would expect them to be addressed or referred to within this section?
Yes, Your Honor?
Because this section you're reading far more robustly as a stronger bar than, of course.
Yes, Your Honor.
Right.
Section 215.26 on its face, and is interpreted by the courts, is an absolute statute of non-claim that, if it's not satisfied, deprives the court of subject matter jurisdiction to consider the refund. Now, the courts, Victor Chemical, made it clear. If we could consider fairness, well, there would be times when it would be fair to reopen that period. But the Victor Chemical Court said, while we might like that as a matter of public policy, the legislature said no. Any claims for refund filed outside the statute of limitations, with that limited exception of Section 220.23, when there was an amended federal income tax return and the taxpayer has an additional 2 years. Other than that, all claims are barred. Now, these refund claims go back very far in time. Florida, in Section 213.33 and 213.34, Florida places strict limitations on record keeping on the time of audits. And the taxpayers must maintain records for the time for which the department can issue an assessment. The deadline for assessments, section 95.091, generally 3 years. But if a taxpayer doesn't file a return at all, then the department could go back to the dawn of time. So if taxpayers file a tax return and there's no tax evasion, the department cannot audit more than 3 years before. And so taxpayers cannot be expected to maintain records.
Can you tell us how you read 220.02, the legislative intent?
Yes, Your Honor.
About utilizing the federal code?
And I think we need to read section 220.02 and 220.03 together, because section 220.02 states that Florida, for purpose of efficiency, adopts federal concepts and as developed, not enacted. Now, the legislature could very well have said, changed those two words, concepts of law, and developed in the federal income tax. It could have been changed to law or statutes and enacted, but they didn't. So those two phrases, developed and concepts, would refer to concepts like realization of income. Several of the cases that were cited in the briefs, SRG Corp., Heffler Construction, deal with realization of income. Those are concepts that are common both for federal income tax and Florida income tax. Concepts of law are not statutes enacted by the legislature. In the 75 or more years since Section 215.26 was enacted, there has not been a single case that has applied the federal rules mitigating the federal statute of limitations to mitigate the Florida statute of non-claim. Victor Chemical makes it clear that courts don't even have that power, even though in a particular case it might be equitable to do so. But it's a question of jurisdiction, subject matter jurisdiction for the courts. And the Florida Supreme Court reiterated the same principle in the Nimeth case many years later. So the courts uniformly have found the statute, section 215.26, to be a statute of non-claim, but there is, by contrast, a statute of limitations on tax assessments, section 95.091. The Florida legislature has a very fine-tuned set of deadlines for each step in the process of filing tax returns, of audits, of assessments, and refund claims.
Do you ever think that this 220.02 legislative intent provision, subsection 3, would be determinative of something, a case that we would have? I mean, it's an intent statute. I think that your brief went into that it's meaningful that this is about legislative intent and it is the intent of, as opposed to an affirmative.
Well, Your
section.
Honor, I believe that we would agree with your observations earlier this morning that it's far more efficient to be able to use the terms, the definitions developed ever since 1913 for the federal income tax. So you have realization of income that was determinative in Heffler Construction, SRG Corp. You have profit and loss. You have similar terms that mean the same thing in Florida as they would for the federal system. I see my time is almost up. We would ask that the court affirm the portion of the decision below that found that Verizon's refund claims were untimely and therefore barred pursuant to section 215.26. If there are no further questions, I'll be seated.
Thank you, Counsel.
Thank you, Your Honor.
Before you get started, counsel, I'll ask you to, can you respond to Appley's argument distinguishing Seaboard?
Seaboard Coastline case? Yeah, I'd love to. That was one of the points I was going to address, so it was a good segue. The fact that Seaboard Coastline developed with amended returns is irrelevant, and I can explain pretty quickly why. Imagine the reason why Seaboard Coastline filed an amended federal return had to do with an issue that Florida treated differently. The fact that Seaboard Coastline filed a federal return with an amended return and therefore was required to file a Florida amended return would mean nothing in that case, because Florida wouldn't have adopted the change that caused the federal amended return to be. So again, the fact that it was amended return at issue in Seaboard Coastline is irrelevant. What's important in the case is that this court said federal concepts, in that case a claim of right doctrine under 26 U.S.C. 1341, were adopted as part of Florida law. The department didn't challenge it in that case. That particular provision, which is in the same subchapter of the Internal Revenue Code as the federal mitigation provisions, was part of Florida law. That is the important takeaway from Seaboard Coastline, not the fact that Seaboard Coastline had to file an amended return. Your Honor, there's a couple of things I want to make clear in the last minute that I have, and I think that they're critical to this case. Number one, the department does not dispute that the legislature intended Florida's taxing regime to borrow from the Internal Revenue Code. Number two, the department also does not dispute that Verizon qualifies under the federal mitigation rules for the requested refunds. They don't challenge the year, they don't challenge the amount. The department does not dispute that federal statute of limitations, like the Florida statute of limitations, is a statute of non-claim. Finally, the department does not dispute that the mitigation rules are an exception to the federal statute of non-claim. Your Honor, the mitigation rules apply in this case because the legislature has not expressly stated to the contrary, and the rules are not manifestly incompatible with the intent of the Florida legislature. For the foregoing reasons, Verizon respectfully requests that this court reverse and issue an order directing the trial court to grant summary judgment to Verizon. Thank you.
Thank you, counsel. All right, if council wants to take whatever time to gather themselves, but then we can move right into the